Good afternoon or good morning to you. Welcome to today's Venable Nonprofit Organizations Practice Group webinar. It's titled Using Affiliates to Expand Your Nonprofit Reach. I'm George Constantine. I co-chair the Nonprofit Organizations Practice Group here at the firm with Janice Ryan. Before introducing our speakers in the program further, I just want to give a quick plug for next month's program. We have a webinar that's going to focus on alternatives to traditional grant making for nonprofits. So things like program-related investments, convertible grants, and all those other sorts of unique and sort of hot types of grant making that organizations are doing. And one of our colleagues will be presenting on that with a client that works with a nonprofit organization as well. That session will be on November 20th. Between 12 and 1 Eastern time. Keep an eye out on your inbox for the actual invite for the program. It hasn't gone out yet, but it will shortly. Now back to today's program. This is a good topic to cover, one that comes up a lot in our practice. A lot of our organizations we work with have really families of organizations, not just a nonprofit 501c3 or 501c4 or 501c6, but maybe all those combined, or a political entity, or maybe a for-profit. And when that happens, there are unique opportunities that allow organizations to maybe maximize revenue or take advantage of different types of missions that they may not be able to sort of be active on in their main groups. So having an affiliate has helped a lot in those situations as well. Of course, operating and working with affiliates has some challenges legally and from a management standpoint. And so our colleagues today are going to share with you the benefit of their experience in working with organizations with these affiliate relationships, and hopefully help you manage that going into the future. So I'll introduce briefly our speakers. First, I'll introduce Lindsay Nathan. Lindsay's a partner here in our practice. She's a very seasoned attorney who's worked on both nonprofit and political law issues while here at Venable. Issues like governance, tax exemption issues, fundraising, campaign finance, lobbying law issues. Lindsay's very well-versed in all those areas. Before joining us, she was the former chief legal officer at the nation's largest gun violence prevention organization. And previous to that, had held a position with the Office of the Governor of New York. So happy to have Lindsay join us. And speaking with Lindsay today is Brian Melnick, a colleague of ours who works here in the DC office, works regularly on nonprofit and political law issues as well. Brian has worked with us for a number of years, and prior to that was a professional staff member for the Committee on Education and the Workforce in the House of Representatives. You're in great hands with these two, and I'm sure you'll learn a lot. With that, I will turn it over to Lindsay, let her get started.
Thank you so much, George, and thank you all for joining us today. We're really excited to talk to you about using affiliates to expand your nonprofit reach. Go ahead to the next slide. I just want to do a brief overview of the agenda, and then I'll turn it over to my colleague Brian to get us started in earnest. So first, we'll talk a little bit about creating affiliated entities, why nonprofits might choose to do this, what are the different considerations that they take into account, as well as the potential benefits and downsides. Then we'll pivot into talking a little bit about how to manage affiliate organizations, sort of the competing interests of separateness and control. And then finally, we'll do a little bit of a deeper dive into the legal issues that come up when you create either a for-profit enterprise or nonprofit affiliates. So with that, I will kick it over to Brian to get us started.
Thank you, Lindsay. As Lindsay mentioned, we'll be starting with some reasons and considerations for nonprofits and why they might want to create affiliated entities. There are a number of different reasons that a nonprofit, a core organization, might want to create affiliated entities. And we'll discuss several of those here today, but they're often driven by the intersection of their tax-exempt status and their business needs. So is there a business reason for expanding and creating a nonprofit affiliate? And can your organization do that activity, or they might not be able to do it, and that's why an affiliate is more appealing. And so we'll be discussing a lot of those different reasons here today. And And during our discussion, we'll be talking about a number of different types of tax-exempt organizations throughout the presentation. Of course, we'll be talking about 501c3 charitable and educational organizations. These are your traditional public charities that most people think of. We'll also be talking about layering into kind of an organizational umbrella, 501c4 tax-exempt organizations, also referred to as social welfare or advocacy organizations. 501c6 organizations, which are your typical trade associations or business leagues, and 527 political organizations, so PACs of all sorts of different flavors. And then also, when we're talking about this, these affiliated structures, we'll also be talking about different types of affiliated entities. Of course, the most common is probably a corporation, forming a new corporation to be an affiliate. This could be both either a tax-exempt organization or a for-profit organization. And then LLCs, which can come in multiple different flavors as well. They could be disregarded or pass-through entities, which are really folded up into the core organization. They take on the characteristics of the core organization, including their tax-exempt status. They're not separately taxed. Or if some organizations decide to go with a separately taxed S Corp corporation as an affiliate or as a LLC. And there are different considerations for both. You might have better risk mitigation if you go with a separately treated organization, but if that's not really a concern and ease of administration is a priority, then going with a disregarded or pass-through LLC might be the more appropriate choice. There are a number of different potential benefits for creating affiliated entity structures. We'll go through a number of them here, touch on them briefly, and then on the next slide, we'll discuss some of the downsides and potential risks that you should be considering when you're deciding whether to proceed with an affiliated organization structure or kind of stand pat. Perhaps the most prominent reason for expanding and forming an affiliated organization is programmatic expansion. So perhaps your organization is a C3, but it wants to engage in additional advocacy, both through lobbying or political activities. And as you know, a 501c3 might be limited in carrying out those activities, particularly political campaign intervention activities, which a 501c3 cannot do under any circumstances. So expanding the programmatic reach of your core organization to include other organizations that might have different abilities, different limits on what types of activities they can do are certainly something that organizations think about and consider all the time when they're considering creating affiliated structures. Professional certification activities are another example of programmatic expansion. This is professional certification activities are typically carried on by 501c6 organizations, and the IRS has held that professional certification activities do constitute a private benefit. And so to mitigate the private benefit risk posed to 501c3 organizations, it may make sense to form an affiliated C6 to carry on the certification activities while still maintaining the core purpose and mission of the core organization and not damaging or presenting unreasonable risk to that core organization's tax-exempt status. Another reason that an organization might consider forming an affiliated organization is for revenue generation. As we all know, tax-exempt organizations can generate some unrelated business income tax, but there can't be too much. It can't become a substantial portion of their overall activities. And so forming a for-profit entity, affiliated entity to house those unrelated activities might be wise to mitigate risk of too much UBIT for the core organization. Forming a for-profit organization might also enable the core organization to attract outside investment from and offer incentives that they may not otherwise be able to offer. Tax-exempt organizations generally do not have owners, and so forming a for-profit entity, you might be able to attract investors to come in and help seed fund the new affiliated organization by giving them a stake in the company that the nonprofit will be running through this affiliated organization. The core organization would not be able to do that, offer investment opportunities if they were to run those types of programs within the core organization itself. It might also be appealing if the ultimate goal is to spin off or sell the for-profit affiliate later on down the line, or the for-profit enterprise or activities that the core organization is anticipating or considering doing. It might be more appealing to outside companies if it's already packaged in a separate for-profit entity to come in and purchase that or spin off the organization. It might mitigate or alleviate any sort of administrative burdens at that time by it's already in a separate organization and easier to do it at that time. It might also be a good avenue to attract different types of talent. Similar to attracting outside investment, you could attract different types of talent by offering equity and equity in the for-profit affiliate, something that the core organization, tax-exempt organization, cannot do. And so that might be appealing if the organization is looking for creative ways to attract talent to come in and carry out the activities that it wants to achieve in this for-profit enterprise. And then also the for-profit affiliate might also be able to pay more closer to market compensation without the risk of or with smaller risk of private benefit issues or private enrollment issues or excessive executive compensation. Risk containment is also another appealing objective for setting up these sorts of affiliated organization structures. They could create brand distance for controversial programming or advocacy. If you want to separate a controversial activity from your core organization's activities, housing those controversial activities in an affiliate might be appealing. Asset protection or insulation. This is if you're considering, you might have some more risky assets, in particular real estate, and you want to mitigate risk of facing the core organization. You can house that real estate asset or any other sort of risky asset in a separate organization to try and contain that risk to the affiliate. If the organization is considering a substantially unrelated activity that might pose risk to the organization's tax-exempt status, housing it in a separate affiliated organization might be wise to mitigate risk that this unrelated activity kind of subsumes or becomes too substantial in comparison to the core organization's charitable or otherwise tax-exempt mission or activities to protect the core organization's tax-exempt status and insulate it from that sort of risk. Or creation of a supporting organization if the main organization is facing challenges. Supporting organizations are often formed to specifically support one or more other tax-exempt organizations. And that might be a way, forming a supporting organization might be a way to alleviate the challenges that the core organization is facing. And that's kind of a nice segue into revenue generation. And this would be, compared to the for-profit, this would be forming another nonprofit organization. That could be done through a supporting organization. A C6 or a C4 might find it appealing to form a foundation affiliate to attract different types of donors who might only want to contribute to an organization where their donations are deductible. And so forming a C3 foundation affiliate might be appealing in that respect to engage new donors. And then there are numerous other sorts of business reasons that we'll discuss throughout our presentation today. But international expansion might be one of those other business reasons to think about as you're considering whether the organization should consider an affiliated structure. Now, although there are a number of different benefits for creating an affiliated organization structure, of course, there are downsides to consider and risks to consider as well. And we want to go through a few of those here today. First off is whether the administrative burden is really going to be, is the juice worth the squeeze? Managing multiple entities requires operating separate bank accounts, books, records, activities of board meetings, staffing, those types of things. So administrative burden is something certainly to keep in mind, both from a capability standpoint. Does the organization have the capability of managing multiple entities, but also from a cost perspective as well. We'll get into cost a little bit in the next bullet. There also needs to be consideration to managing and sharing resources between the organizations, implementing some sort of shared services agreement to ensure that activities that one organization is doing, but another organization can't do or can only do in limited amounts, will require careful planning and tracking of staff time, cost tracking to ensure that some activities aren't imputed to the other, or an organization isn't, particularly a C3, isn't improperly subsidizing the activities of another organization that the C3 shouldn't be subsidizing. And then, of course, there's also going to be kind of the run-of-the-mill filings that you have both at the state and federal level. But when you're talking about adding on multiple different organizations, that can create some extensive administrative burden to consider. So, for example, there'll be separate registrations for each organization to file with the states where they're incorporated or where they're operating, both initially and then on an ongoing basis to maintain those registrations. There'll be tax reports due both at the state level and at the federal level, including the IRS Form 990s. So if you've got separate affiliated organizations, each of those organizations will need to file their own tax filings, their own Form 990 each year, something to keep in mind. And then kind of ongoing maintenance, as I mentioned. And part of the administrative burden kind of goes into cost. Of course, there are startup and ongoing maintenance costs. That's driven a lot by the administrative burden that the organization will now have to be handling. Does the core organization have the financial resources to absorb those costs and maintain their devotion to their current mission and ensure that they can continue doing the activities that they were formed and are purpose-driven to do. There might be additional costs for building out infrastructure and the need for additional management resources. If your company or if your organization decides that it doesn't necessarily have the administrative capability to handle all of these new burdens and tasks that it's going to need to do to effectively manage their affiliated organizations, then it might need to consider a management organization, some sort of outside consultant to help with those types of things. All of those types of engagements will lead to higher costs for the core organization and the affiliated organizations as well. Mission creep and mission drift, I kind of think of as two sides of the same coin. Mission creep really are the affiliated entities serving the mission of the main entity. Even though you might form an affiliated organization to have a mission that is substantially aligned to the core organization, there might be opportunities for that affiliated organization, the activities that they're carrying on to perhaps take away from the core organization's activities, or lead the core organization away from its original intent and purpose. And so something to keep in mind is how do we keep ensure that our core organization mission doesn't divert too much from what our original intention was. Mission drift, like I said, on the other side of the coin, when you've got different leaderships, boards, and missions, that can lead to different organizations having different priorities. And although the organizations might have a substantially aligned mission at the onset, as the different leadership structures take hold, the different boards take hold, there's risk that the affiliated entity their mission might drift over time, given the different opinions and leadership styles of their unique board. And so we'll talk about throughout this presentation some ways to try and contain or mitigate those risks, but certainly all things to keep in mind. So with that, I'll turn it back over to Lindsay to talk about some key considerations for managing affiliates.
Thanks, Brian. So one of the things I think, comes up a lot when we talk about the creation of and the implementation of different affiliates is how do we manage the different competing considerations? So, in order to get the benefit of having the organizations or the affiliates be truly treated as separate entities, we need to maintain some level of separateness between the two organizations or the multiple organizations, depending on what the structure is. But at the same time, obviously, the main organization or the parent organization in some cases, really needs to also maintain control to, avoid the mission creep or the mission drift problem that Brian mentioned just a few moments ago. So how do we balance that separateness versus control? How do we ensure that the affiliates remain aligned in their missions? How do we do this in a way that protects the integrity of each entity's distinct tax statuses? We want to make sure that we're not imputing the political activities or the for-profit activities of the affiliate to the nonprofit in some circumstances. And then ultimately, how do we do this while ensuring that all of the affiliates are being managed in a way that kind of balances all of those competing interests? Like those are all the things that you want to sort of think about as you're thinking about how to structure the affiliates. So when we talk about separateness, this is really important. As you know, I'm sure, if you are working with a nonprofit organization, one of the most important rules is that you ensure the integrity of the organization. And part of that is by making sure that you have, separate books and records, that you have governance, that you're, observing all the corporate formalities of the organization to ensure that you don't have liability for individuals or, the activities of the organization are not imputed to another organization or vice versa. And that's true when you're talking about managing affiliates. You need to make sure that the new entity is properly capitalized while simultaneously avoiding commingling of assets and accounts. You need to make sure that you have separate boards and governance, meetings and minutes, policies and contracts, even if those policies and contract templates are essentially, the same across various entities, they need to be separately incorporated or adopted by each entity to make sure that each entity is treated as its own sort of separate organization. And then, to the extent that you have any transactions between the organizations, you want to make sure that that those are properly documented through contracts. So, if you're making grants between organizations, you want a grant agreement. If you're sharing resources between the various entities, you want to make sure that you have a resource sharing agreement in place, and that you have the ability and the proper accounting mechanisms in place to ensure that to the extent that you are sharing any resources, that those are being properly accounted for and reimbursed or, included in the investment into the other entity, depending on sort of what the structure is. But I think the key takeaway from this is that, making sure that the organizations are really treated as separate organizations, even if they have, shared governance or shared mission or any of those things is really important. And on the other side of the coin is control, right? So while we want to make sure that these organizations are separate, it's perfectly reasonable and appropriate to maintain some level of control amongst the various organizations. You can do that in a number of ways. You can do it through a member-manager relationship. So, if a C3 creates a C4 or creates a for-profit entity or another organization, you can have the C3 maintain control over appointing the board while still having the other organization operate as a separate entity. You can have some overlapping board members. I saw in the questions, what's the appropriate number of board members to overlap? You don't want 100% because you want to have some separation, but they can have significant overlap depending on how comfortable you are with having the organizations be treated as related for tax purposes, or if you don't want them to be treated as related for tax purposes for various reasons, then you would not want to have significant overlap on the board. And ultimately, I think also there are other considerations when you're talking about how much control you want to have and how that kind of plays into the appearance of having these organizations be separate. So, to the extent that you have two organizations with shared executive leadership and significantly overlapping board members, even if you treat them separately, and do all the appropriate things for separateness to ensure that the corporate formalities are observed, you might want to have more separation between the organizations just to sort of distance one organization from the activities of the other. So that comes into play a lot. For example, if you have a C3 and a C4 and you want the C4 to engage in some political activities, you certainly wouldn't want to ever get into a situation where the C4's political activities would be imputed back to the C3 because that could jeopardize the C3's tax exempt status. So, all of these things are going to be considerations that you're going to make when you're thinking about how you want to structure your entities and how you want to, what level of control the primary organization wants to continue to exert over the new affiliate. So before we jump into creating a for-profit enterprise, I want to take a moment to give you the CLE code for today. It's Affiliates 2025. That's Affiliates, plural with an S, 2025, no spaces. It doesn't matter if you capitalize the letters. One more time, Affiliates 2025. And Brian will say that one more time at the end of the program as well. So we talked a little bit about the reasons why you might want to create a for-profit affiliate, talking about revenue generation, talking about, activities that might generate too much unrelated business income tax that might be substantially unrelated to the activities of the nonprofit organization, at least from a tax exempt perspective. And so a lot of organizations and a lot of clients that I'm working with right now are thinking about sort of innovative ways to create new enterprises through their nonprofit organizations. And it's very common, especially now with, I think, a lot of nonprofit organizations kind of struggling with donations being down and wanting to find sort of innovative ways to generate revenue. A lot of organizations are turning to for-profit activities, but obviously a nonprofit organization cannot be substantially engaged in commercial activities that do not primarily serve its tax exempt purposes. And it can't create an impermissible private benefit for any private person or entity, including insiders to the organization. So, the potential consequences of doing this directly through the nonprofit organization are unrelated business income tax, as I mentioned before, excise taxes, including taxes on the managers of the corporation, or the directors of the corporation. And then ultimately, to the extent that the activity really is excessive, it could lead to the revocation of the tax exempt status of the organization. So those are pretty significant risks to the nonprofit if the nonprofit were to engage in some of those for-profit activities without creating a separate entity. Separately, we talked about the concept of separateness for organizations and how one of the important components of that is ensuring that the new entity is properly capitalized. So how do you get nonprofit money into a for-profit enterprise, when a nonprofit is supposed to be operating exclusively for charitable purposes, in the case of a C3, or for social welfare purposes in the case of a C4, and obviously for business purposes in the case of a C6. There are a lot of different ways in which a nonprofit can capitalize a for-profit entity. Just because a nonprofit must operate exclusively for nonprofit purposes or tax exempt purposes does not mean that it can't engage in some outside investment or and do other sort of creative things to generate revenue or to expand its reach through other mechanisms that are not just charitable activities. So this is meant to be illustrative because obviously every nonprofit situation would be slightly different, but there are a couple of different ways that typically come up when a nonprofit would like to capitalize a for-profit enterprise. So you can do it through a simple agreement for future equity or some sort of loan or financing equity agreement. You could do it through a licensing agreement. You can do it through shared services. There are any number of ways in which the nonprofit can actually capitalize the for-profit, but obviously all of the transactions must be done at arm's length. They must be done subject to fair market value, and you should have written agreements in place for any capitalization that you're making of a for-profit entity. Separately, to the extent that you're going to take any nonprofit assets or IP or personnel or anything like that and move them from the nonprofit to the for-profit so that you can capitalize on them, you want to make sure that you're doing that through written agreements. And again, it has to be done at arm's length and subject to fair market value. So can't have a situation where even the for-profit organization that a nonprofit creates is getting some sort of private benefit. Everything has to be done at fair market value. I want to talk for a second about unrelated business income. So, I mentioned a couple of times this term UBIT, which is a tax imposed on the income that a tax-exempt organization earns from a business activity that is not related to its exempt purpose. So this is one of the main reasons why I think a nonprofit organization would create a separate entity, because if they engage in substantial unrelated activity, they could lose their tax exempt status. But there might be perfectly good reasons why the organization would like to engage in some of those activities. Again, as we talked about, revenue generation, expanding your reach, coming up with different ways to sort of reach the charitable class or the nonprofit class through activities that wouldn't, otherwise be considered tax exempt. So setting up the for-profit does insulate the nonprofit organization from UBIT to some extent, although you do need to be careful about how you're structuring the relationship between the two organizations, because even having that money come back into the nonprofit organization could subject the nonprofit to tax implications if it's not structured properly. So one thing that we see a lot in these types of arrangements, especially when you have a nonprofit with a for-profit affiliate, is to structure the flow back of funds as dividends, if that's appropriate in the situation, which are not subject to UBIT. There are other specific exemptions to UBIT, or specific exemptions that would apply that would limit any UBIT exposure for the nonprofit. But that's one example that I wanted to mention. Compensation and equity. So this is a big one, I think, and Brian mentioned this at the top of the program, which is that, a lot of times when you have really great nonprofit ideas, you have a hard time attracting talent because you have to pay compensation that is considered reasonable based on other similarly situated organizations. Otherwise the organization could lose its tax exempt status, or the managers or directors could have potential personal exposure in those situations. And so, if you have a nonprofit idea, or if you have an enterprise idea that you really need to pay market compensation to execute on in order to accomplish your goals, you could potentially do that through a for-profit organization. So the individuals who are employed by the for-profit affiliate wouldn't necessarily be subject to the same compensation rules that employees and insiders of the nonprofit would be. That being said, there is obviously an exception for individuals who are currently employed by both organizations, or who, for former nonprofit employees that were employed by the nonprofit within the last 5 years. So, obviously you don't want to waste nonprofit resources, but, to the extent that you need to pay closer to market rates to get the talent that you need to execute on these ideas, this is another sort of creative way in which you could do that. And then finally, I just wanted to kind of give a couple of examples of structures that we have seen a lot of recently. I think the two most common are the LLC and the C corporation, and there are pros and cons to each one of these. It really ultimately is going to depend on what your business purposes are, what you're trying to accomplish, whether you want to, be able to provide equity or outside investment opportunities for to raise capital, whether you're trying to insulate the nonprofit organization from potential risk associated with running the for-profit enterprise, how you expect the funds to flow back into the nonprofit organization. All of those things are going to be relevant as you're thinking about different potential structures for how you would move forward. But two of the most common, that we see are the LLC and the C corporation. I won't go too far into the pros and cons of each of these. As you can see on the screen, I think ultimately how you would want to proceed in this situation would depend pretty, specifically on your particular circumstances and what it is you're trying to accomplish. But just wanted to sort of mention that they're two very common examples. As Brian mentioned before, the LLC can be disregarded. It can also be taxed as a partnership. And then the C corporation, you can have an LLC that is elects to be taxed as a corporation. You can have a public benefit corporation. There are any number of different corporate structures that you could choose depending on what it is that you're trying to accomplish. But these are sort of the two kind of standard, starting points that most organizations will consider. With that, I will turn it back over to Brian.
Thank you, Lindsay. Now we'll be switching gears from creating for-profit affiliates to creating nonprofit affiliates. And first, we'll start with some questions that we think all sorts of organizations should ask before kind of going down the road of creating creating nonprofit affiliates. And that's, why might you need a nonprofit affiliate? Does the organization want to expand its programmatic reach? For example, does it want to carry on some activities like advocacy or lobbying activities that the core organization can only do in limited amounts or cannot do in any amount? And so is that a reason for creating a nonprofit affiliate? Are you a 501c3 organization and it's important to your mission to have an entity with an aligned mission that can do more lobbying or engage politically? Similar. Are you a 501c4 or C6 and and think that having a research or education affiliate will bolster your mission? Or do you have donors, supporters, or members who have encouraged you to expand your work, and the best way to do that is by forming a new type of organization to carry on and achieve the objectives of your donors or members. Or, for example, are you a 501c4 organization but there are potential donors that you would like to support your mission, but will only give to public charities? Those are all reasons that you might consider that might lead you to believe that that forming an affiliate might be a good path to go down. Of course, there's two sides of every coin, and there are a number of reasons that you might decide to wait or kind of test the waters to see whether an affiliate might be something to consider later on down the road, as once you've given the new activity a shot kind of inside the core organization. So one reason why you might wait is you can use an existing entity to achieve your purposes. Could the organization make a grant to another organization to carry out the activities? That would help insulate the core organization from risk considerably. It puts the onus of carrying out the activities or the objectives of whatever the purpose of the grant is onto a different organization. Of course, the grantor, the core organization, will have some monitoring responsibilities to ensure that the grantee is doing what they promised to do when they applied for the grant and you awarded the grant. But that might be an opportunity to kind of shift some of the both administrative burden, any sort of risk to the organization to a different organization through a grant arrangement, whereby the core organization gives money to another organization to carry out those activities. Another reason why you might wait is that the core organization is part of some sort of coalition, and a coalition partner might be able to more effectively achieve the objectives that the organization wants to achieve, or maybe they're already doing it. And so the core organization might not want to devote its resources, and maybe it makes more sense to collaborate with the coalition partner to take care of those activities, or the core organization can work with the coalition partner to find ways to enhance or add on to or build upon the activities that the coalition partner is already doing or is already anticipating that they'll start doing in the near future. And maybe the core organization already has a structure of affiliates, and creating a new organization would overcomplicate things. There might be something already under the umbrella of the core organization that is able to do the activities that it wants to achieve, or is just better situated to do so. And so those are three reasons why you might want to consider using an existing entity rather than perhaps jumping the gun and forming a new affiliate from the outset. Another reason why you might wait is that the core organization has insufficient funds to form and sustain a new organization. I touched on this, and Lindsay has touched on this in her portions of the presentations as well, but the core organization really needs to determine whether the juice is worth the squeeze, and whether the core organization has the resources to effectively manage the new administrative burden that comes along. And there might be some creative ways to kind of test the waters to see if the new activity that you want to do has longevity, or is kind of something that is one and done. So the organization, before jumping to creating a new affiliated nonprofit, might consider a pilot program or a demonstration project to test whether that program is scalable, whether it's got legs and will continue to be something that the organization wants to do in the future, or whether it's something that the organization just wants to do for a short period of time. For example, if a C3 organization isn't traditionally engaged in advocacy, but an issue of public importance comes along, a bill comes along that is of importance to the C3, but the C3 doesn't anticipate that advocacy will be part of its mission, once this bill has either been passed or it dies in the legislature. So a pilot program might be the best way to do that, to see whether additional advocacy activities arise in the future. or any sort of business activity is worth continuing for a longer period than just a short period. And also, when you contain something to a short, pilot program, you're mitigating the risk that, to at least to some extent, you may be mitigating the risk that the new activity that you're undertaking might be considered substantial compared to your existing activities, and that's important if the new activity is unrelated to the core organization's tax-exempt mission. You might also consider, creating a new brand. That, of course, doesn't help necessarily with the risk mitigation that creating an affiliated entity might do, but it may create some at least public separation from an activity for the core organization to create a new brand, file a new DBA in states where it's operating, and then run the new program under that new brand to give some distance. And that will help alleviate some of the administrative burden of creating a new organization, and also kind of give the separation that the organization might be seeking when it's considering whether, okay, do we do this in-house? Do we do this in a new organization? Why don't we try starting it with a new brand? And if that brand has legs, then maybe it does make sense later on down the road to move that brand into a different affiliated organization. And then a third reason why you might wait is that the risk just doesn't justify the cost. We've touched on this throughout the presentation, but is the administrative burden too great? Is the affiliate's mission incompatible or will divert critical funds from supporting your current projects and priorities? This is that mission creep that we discussed earlier in the program. And then also, your donor staff or members may not be on board with creating a new affiliated structure, given all of the hoops that the organization might have to go through, the cost that the core organization might face, and then other risks that the organization might face as well. Next, we'll kind of shift gears slightly into kind of taking a little bit deeper dive into one of the main reasons that an organization might form a affiliated nonprofit, and that's bolstering nonprofit advocacy. This is certainly something that we see on a day in and day out basis in our practices, and so we wanted to just give it a little bit deeper dive on this topic. And there are a number of reasons why organizations might do it. They could be doing it to protect and advance their organization's members' interests and issues. They might see new opportunities. I used an example on the previous slide where an organization might not typically be involved in advocacy activities, but a new bill comes up or a new public issue comes up, and they find that the time is now right to enter into the advocacy space, but are limited because of the form of their organization. Perhaps they're a C3. And as Lindsay has mentioned, and we'll talk about a little bit more on the next slide, so the C3s are limited in the amount of lobbying and other types of advocacy that they might be able to do. So those new opportunities might present an opportunity for your organization to expand and create an affiliate. That's kind of similar to lobbying and political activities. Maybe an affiliated organization can do something that the core organization cannot do. Believe it or not, enhancing reputation is also a key consideration for determining whether an organization wants to create an affiliate. Perhaps housing those perhaps more controversial activities into a different organization will lessen any risk to the reputation of the core organization. But the kind of complementary activities of the affiliated organization may also bolster or enhance the reputation of both the core organization and the kind of umbrella of organizations as well. So something to consider, whether creating an affiliate might help your reputation, both with the public or with elected officials, if advocacy is a key component of your priorities at the current time. Promoting favorable regulatory climate might be another reason why an organization considers creating an affiliate or engaging with different supporters or donors. And the classic example here is a C4 or a C6 that wants to engage donors that are interested in giving to an organization where their donations are tax deductible for the donor. And so creating an affiliated C3 might be something to consider. Now, on this slide, we'll talk a little bit about the different kind of types of activities that are four key types of organizations that we've been discussing throughout this presentation can do, or what they can't do. And these are 501c3 public charities, C4 social welfare organizations, C6 trade associations, and 527 political committees. C3 public charities, donations to them are likely tax deductible for the donor. So that is an appealing feature of having a C3 organization within your corporate umbrella. However, there are limitations to operating as a C3. C3s cannot engage in any campaign intervention whatsoever. So that means no activities to support or oppose any candidate for public office at any level of government, federal, state, or local level. No endorsements, no using corporate resources or making contributions to political committees or candidates. Even if the organization doesn't want to help other organizations, the organization cannot itself disseminate communications to support or oppose candidates or parties. And C3s need to be careful because campaign intervention can often be, as defined by the tax code, can be broader than what it might entail under federal or state campaign finance laws. So even if you're not using in a communication magic words, vote for or vote against a particular candidate or party, the communication still may be viewed as political or campaign intervention under the IRS's facts and circumstances test. So something to keep in mind is even if you're not directly advocating for the election or defeat of someone, if your communication is still tends to attempt to influence an election, it's something that a C3 can't do. C3s can do some lobbying, but it can't be a substantial part of their activities. So thinking about using another organization like a C4 or C6 to bolster those advocacy activities through an organization with an aligned mission might be appealing. And C3s, as we've kind of alluded to throughout, may establish and share services with C4s and C6s, but may not, under any circumstances, establish or share resources or services with a political organization, a 527 organization devoted to those types of activities. C4s and C6s, we group here in this middle column, not because they're the same types of organizations, but because they have similar types of abilities and restrictions on the types of the activities they can do to remain in compliance with the tax code. So unlike C3s, C4s and C6s, donations to them are not deductible for the donor. But for membership organizations, a portion of the dues that are not attributable to lobbying or other political activities may be deductible by the member as a business expense. So there's some give and take there. Unlike C3s, C4s can do some political activities, but similar to C3s, with respect to lobbying, the C4, the C6's political activities cannot be a substantial part of their overall activities. It cannot be a primary purpose of that organization activities. There's a lot of gray area as to what amounts to a substantial portion of an organization's activities to determine what the appropriate line is, how much political activity is too much, or how much really fits within the parameters of the tax code. But generally, we advise that there's a certain percentage that the organization, taking into account all of the different types of activities that the C4 or C6 is doing, to determine whether that the political activities are within reason or are too much and incompatible with the tax exempt mission of the organization. C4s and C6s, unlike a C3, can do unlimited amounts of lobbying. So they can become really useful tools for C3s wishing to increase their advocacy activities. And unlike C3s, C6s can establish and share services with 527 organizations, so long as those activities don't amount to, aren't too much and amount to a primary purpose. And of course, C4s and C6s can establish affiliated C3s for many of the reasons that we've discussed already. 527 political committees. 527 is the section of the tax code and is really an umbrella term for all different sorts of political action committees. You've got your traditional non-connected political action committees, or you've also got separate segregated committees. So this is your typical connected corporate PAC, whereby a corporation, given that they can't make direct contributions to candidates, may form a connected organization subject to certain rules under the campaign finance rules and laws to start making contributions to candidates and other parties. And then also super PACs, which are really independent expenditure only committees. They're not making contributions to other candidates or parties, but are themselves running communications and other independent expenditures to support or oppose candidates or political parties. Believe it or not, 527 organizations can do some lobbying, but like similar paradigm to the charities with respect to lobbying and C4s and C6s with respect to political activities, the lobbying activities and issue advocate activities cannot be a primary purpose of the 527. The 527 must have a primary purpose of influencing elections. And 527s can be established and share services with C4s or C6s, but there really needs to be a firewall between C3s and the 527s. Now, that doesn't mean that there can't be a C3 in a structure that also involves a C4 and a PAC, but the C3 cannot be the organization that's establishing the PAC. The C4 or the C6 is the organization that would need to establish the PAC, and there need to be important safeguards put in place to ensure that the C3 isn't subsidizing or contributing to the political campaign intervention activities of the 527. There are a number of different risks that an organization should consider when they're deciding whether to create an affiliated nonprofit organization. Perhaps the most prominent and most important is whether the affiliation will create risk that the core organization will lose its tax-exempt status. Here, we've cited a public letter ruling that established that an entity that used 501c3 resources to support a 527 organization owned by a for-profit subsidiary could lose their tax exemption. So important to keep those safeguards in mind, and definitely keep in mind that it's extremely important to use caution when sharing services to avoid situations where an affiliated organization's activities might be imputed to the core organization or vice versa, risking loss of tax exemption for either the core organization or the affiliate. Whether the affiliated organization's activities will result in any sort of tax penalties or result in reputational risk to the core organization. And this is particularly important if the affiliated organization is using a similar brand, but carrying on a pretty controversial activity. The organization needs to consider what type of damage that might make to the core organization's reputation as well. Whether donor or members might complain about the new organization's activities. And then also donor disclosure is something also to keep in mind. Whether the core organization, if they're making contributions to an affiliated organization, whether any sort of federal or state disclosure law might require that disclosure of the core organization making those contributions, or perhaps more importantly, might require might include a nesting doll provision that requires the core organization who's making the donation require the disclosure of that core organization's donors as well. All things to keep in mind. Here on the next slide, and then I'll wrap it up quickly because I see we're at time, are some practical approaches to managing the risks that we just discussed. And this all really comes down to balancing separateness and control, which Lindsay discussed in greater detail early on in the presentation. But control is really going to be important to avoid affiliates going rogue, and that can be achieved through governance overlap, appointing directors, or giving the core organization the ability to appoint or remove directors. If the affiliated organization is sharing brands, intellectual property, logos, marks, the name, those types of things, building in provisions into some sort of affiliation agreement or shared services agreement that allows the core organization to revoke those IP rights from an organization that doesn't that stops aligning with the mission of the core organization. Strong termination provisions in those shared services agreements, and then ensuring that the organization, through its leadership, all the different organizations under the umbrella maintain fidelity to their respective missions and tax statuses, given all the different nuances between the different types of organizations. Now, of course, you'll need to balance that sort of control with separatists to avoid, an affiliate's activities being imputed to your organization. And that all comes through corporate corporate governance, branding. Separate websites will be key to ensuring that a C4's lobbying activities aren't necessarily imputed to the C3, making sure that there's some distinction between the organizations when on public-facing communications, to ensure that the advocacy or the political activities are really coming from the organization that is allowed to do those, and the charitable activities are coming from the C3. Resource sharing, ensuring that if there is resource sharing going on, that each organization is paying their fair share, and so that one organization isn't improperly subsidizing the activities of another organization, especially when that other organization is carrying on activities that the core organization cannot do. And then record keeping, of course, is going to be vitally important to ensuring that the organizations maintain their separateness, separate books and records, separate meetings, separate boards of directors, and all the separate things that go along with those kind of separate entity operations. So with that concludes our presentation. I do want to tell everyone the CLE code once again for today's presentation. That's affiliates 2025, affiliates plural with an S, 2025, no spaces, and capitalization does not matter. So thank you. It's been a pleasure chatting with you all today, and we look forward to doing it again.